Good morning, counsel. Please proceed.
Good morning, Your Honor. May it please the Court, James Bonfiglio representing Mr. Fernandez and Ms. Kovar. I'd like to divide my time 7 minutes and reserve 3 minutes for rebuttal.
All right.
Thank you. If it please the Court, I will omit a recitation of the facts and go directly to my argument. There are 3 points that I would like to discuss, which were outlined in my initial brief. First, there was a lack of standing that the plaintiff had when it filed the action, and it dovetails with the similar argument of the fraud of the court motion that I filed below with respect to the 4 different versions of the promissory note that were produced during this litigation. Lack of evidence to establish reformation of the mortgage, and the last one is the defective, what we believe is the defective notice to accelerate.
Let's deal with that one first. What prejudice to the homeowner was there via any defective notice? Was he unaware that he was being foreclosed on, or not foreclosed? Was he aware that he hadn't paid? And that
No, obviously they knew that they had not paid. The case law had not been developed at that point in time with whether or not there needed to be established prejudice, but by the same token, the lender did not plead as a reply to my affirmative defenses that there was a lack of prejudice. So that issue was never framed by the pleadings, and no evidence was ever presented on that particular point. The problem with the notice to accelerate, as we are now getting into the case law, is that there has to be substantial compliance, but the problem we now have, and as my initial brief outlines, I believe we have so many problems with the notice to accelerate that the exceptions are essentially eating up the rule. And at what point is there no compliance and substantial compliance? We have a number of issues with respect to the notice to accelerate: the failure to tell the exact amount, the failure to tell the client exactly where to pay, failure to tell the client exactly how much it needs to pay.
Once the homeowner stopped paying their mortgage, I guess it was a husband and wife?
I believe
2 different names.
Yeah, I believe they were married after the wife took out the mortgage and the notes. So the mortgage, I believe, was in the name of the wife. And then they had to foreclose Mr. Fernandez as the husband because he had a spousal interest that arose after the execution of the mortgage.
So after they stopped paying on the note, did they ever contact the bank and say, can we work this out in any way? Well,
there were apparently conversations in the bankruptcy court that I was not privy to because I did not do the bankruptcy. With respect to the foreclosure action, none that I am aware of in the record. I would like to address the lack of standing, if there are no more questions with respect to the notice to accelerate issue. It is undisputed that U.S. Bank filed this action in its representative capacity for this, I'm going to call them the Rask Trust. The problem is that the evidence established, we have essentially 4 different versions of the promissory note. The first one is the version of the promissory note that was attached to the complaint and filed in response to my client's request for production early on in the case. And the evidence showed that the payee of the note was, I believe, United Funding. And then we have the second version of the promissory note, which was filed in bankruptcy, which showed the same blank endorsement and an allonge with a blank endorsement by the same payee. And then you have an assignment from MERS, I believe it was MERS, to U.S. Bank as trustee. And the court has to recall, during the 5 years of litigation leading up to the next version of the promissory note that we saw, we were defending this case based on their motion for stay relief, which essentially said we're not relying on these open endorsements to prove our standing. We're relying on this assignment, which is what they presented to the bankruptcy court to say, this is our standing, these open endorsements, but we also have this assignment to U.S. Bank as trustee without identifying the trust. Then And so that resulted in my client's affirmative defense, lack of standing, because it's our position when you have an assignment under Florida statute, I think it's 689.07, 2 and 3, when you have an assignment to a trust that does not identify the trust, the party with standing to foreclose the mortgage is the trustee in its individual capacity, not in its representative capacity. And of course, then we had the May 2014 trial. A few weeks before that, we took the child's deposition, and that resulted in the third version of the promissory note. The bankruptcy open endorsement disappeared from that version of the promissory note, and they produced a copy of the note with the special endorsement from the original payee to, I think, residential funding, and then residential funding filled in the special endorsement to U.S. Bank as trustee, which matched the assignment. In other words, the endorsement on the third version of the promissory note was U.S. Bank as trustee, and again, it doesn't identify the trust. So we have U.S. Bank who holds, it's our position under Florida Statute 689, in its individual capacity, suing as a representative for this trust. And that was our standing defense. Then, and of course now the allonge, the open endorsement on the allonge, disappears. Where is that allonge? And as the record shows, we took the deposition, I call it the child's deposition, the child's version of the note. She couldn't account for the fact that where this allonge went to, and how did these endorsements that appeared in your which appeared as open endorsements in your bankruptcy, your servicing agent swore that these were the copies of the note that you were seeking to enforce. Where did these come about? And she didn't know. Then we go to the May 2014 trial, where they produced the original note. Again, the original note is, the original allonge is gone, and now they created this new allonge, which identifies U.S. Bank as trustee in the proper name of the trust, which of course they contended established the deposit into the trust that predated the filing of the lawsuit. Well, under the case law that's developed on these deposits into the securitized trusts, even though we have an endorsement into the securitized trust, that endorsement did not place the note into the trust until long after the lawsuit was filed, sometime before the 2015 trial.
So when the complaint was filed, there was a note with a blank endorsement, right?
Correct.
So if they had done nothing, if they did nothing subsequent to that, if they hadn't added the additional endorsements, would that have been enough for standing?
It would have been, except for the fact that the testimony at trial and Ms. Child's testimony established with this screenshot. You may recall I emphasized that in my brief. There is a screenshot taken of the note by the servicer which predated the filing of the lawsuit, which had the special endorsements stamped onto the note. So that even though the copy of the note attached to the complaint, granted, did have the blank endorsement, the true state of facts, according to their own testimony, was that this blank endorsement was filled in, and it was payable to an identifiable person.
Right, so then at trial, that you're right, they had more, but they also, didn't they have testimony explaining how it went from the original lender and ended up with the bank?
Well, what the witness testified to is that they created the special endorsement from U.S. Bank as trustee without identifying the trust to the Rask Trust in order to, what he testified to, is complete the shelf life, which meant deposit into the trust. So they conceded at trial that the actions with all of these different versions of the promissory note did not properly deposit this note into the securitized trust until the creation of this endorsement, which Mr. Blanchard conceded at trial was not created until 2013 or 2014, to what he said completed the shelf life. And when I asked him what did that mean, he essentially said to complete the deposit into the securitized trust. And of course, looking at the securitized trust, which was in evidence. The securitized trust showed that United Residential couldn't deposit the note into the trust, residential funding couldn't deposit the note into the securitized trust, and U.S. Bank as trustee couldn't deposit the note into the securitized trust. So the line of authority, even though they may claim that the securitized trust was the owner of the note, despite all of that, it wasn't properly deposited into the trust, and they didn't have standing to sue until they created this new endorsement. I see I'm running a little bit over my time.
Okay,
No.
we'll call you back up for a rebuttal, just a very short rebuttal. Well, because your briefs lay it all out very well for us.
Thank you. I appreciate that, Your Honor. Thank you.
May it please the Court, Rudy Hill for U.S. Bank as trustee. As Mr. Bonfiglio argued, there are multiple versions of the note in the record. However, none of them are inconsistent with U.S. Bank as trustee standing to foreclose, both at the time the complaint was filed up through the time of trial. In fact, at trial, U.S. Bank placed in the record a business record showing a specific endorsement to it as trustee preceding the filing date of the complaint.
So his argument is that because it says as trustee, but it doesn't identify the trust, that's essentially an individual ownership.
Yes, Your Honor, I believe Mr. Bonfiglio's argument falls under Florida Statute 689.07 and concerns the assignment of mortgage. There was also an exhibit to the trial in this case. However, I would first point out to the Court that the law is in this district and other districts that the mortgage follows the note, and so this Court's focus should be on the note as to whether we have satisfied our burden of proving standing, both at the time the complaint was filed through the trial date. I would also point out to the Court that the assignment of mortgage upon which Mr. Bonfiglio relies actually cites the Florida Statute 689.071, the Land Trust statute, and therefore removes itself from the purview of the statute that he has relied on for this. The note was in the bank itself and not the bank as trustee, therefore no standing argument. And so for that reason as well, I don't believe that argument defeats the bank's standing at the time of the filing of the complaint and through trial. And finally on that point, I would add that even if that statute is applied in this case to the assignment of mortgage, subsection 4 of that statute contains provision that at least I read to say that kind of assignment doesn't affect the relationship between the trustee and the beneficiaries of the trust. What it does is it protects third parties who aren't aware of the beneficiaries from subsequent claims of the beneficiaries that are made before the declaration of trust is made of public record. So even then it wouldn't alter the balance of the trustee or U.S. Bank as trustee's role as trustee, and therefore it still had standing as trustee at the time the complaint was filed. And so the standing argument of Mr. Bonfiglio fails because at trial, which this Court has to look back de novo and see whether the trial court's conclusion that there was standing was correct, the record of trial has the note with a specific endorsement to U.S. Bank as trustee before the filing of the foreclosure complaint, and then the original note was also presented as an exhibit at trial, where there was an addition to it that merely clarified, or as our court representative testified, provided greater detail as to the identity of the trust. And so we believe that the record does support that there was standing sufficient here to permit foreclosure.
Okay, on the reformation issue, how is this distinguishable from the Losner case?
Yes, Your Honor, I saw that you authored that opinion, so I was thinking you might ask me about it. In Losner, well, first of all, let me talk about the trial here. The mistake was a reference to which tract in a development that this particular property subject to foreclosure sat.
Or they called it E?
Yeah, yes.
Where did E come from? Is there an E somewhere?
We're not aware of there actually being an E. We did place in the record a plat from the development for Tract Z, which shows that in fact this property should have been in Tract Z. But the point is, at trial, Mr. Bonfiglio stipulated that, hey, there was a mistake. It wasn't Tract D. In fact, it should have been Tract Z. And that should be the end of the inquiry here, because the reformation count merely seeks to change Tract D to Tract Z. It's not trying to change the address in the mortgage or switch properties or anything like that. The mistake went to the tract identification, and that was stipulated at trial. And so there's a two-part inquiry here, as you set forth in the Losner case. First, you have to show a mistake, and that was stipulated. You also have to show the original intent of the parties. Well, we believe, as a result of the stipulation, that is met here. Unlike in Losner, where it was just blank. The mortgage was blank. The legal description, in the mortgage was blank. And so the court determined, how do we know what the parties originally meant? Well, here, based on that stipulation, Your Honor, we think it's clear that he stipulated that everyone meant Tract Z.
So we don't even have to consider that case out of the 5th District that says that the original parties have to be present to prove that a mutual mistake occurred in light of the stipulation.
Yes, Your Honor, I believe that's distinguishable for that reason. Here, there was a stipulation that obviated the need to show the original intent of the parties. There was also in evidence the plat showing that, hey, this was in Tract Z, not Tract D. And there was also no evidence to the contrary. No one testified, oh, I didn't mean that, I meant this. There was simply nothing to compare what the trial court had in front of it. There was nothing rebutting that. And I would remind the court that the standard of review here is clearly erroneous. And so based on the stipulation, the evidence that was placed in the record about what the parties meant in terms of the tract, the fact that Ms. Kovar, the appellant, only owned property in Tract Z, did not own any property in Tract D. All of that supports the trial court's conclusion in this case and shows that it was not clearly erroneous. In terms of Mr. Bonfiglio's argument relating to his third argument, or actually his last argument, his brief relating to the notice, I would just agree with Mr. Bonfiglio that the record has no evidence of any attempt to show prejudice of any kind sufficient to support a reversal on that. And of course, the court has since the trial in this matter clarified in this district that substantial compliance is the standard. And as we set forth for each of his arguments in our brief, we substantially complied with the conditions set forth in the mortgage. Finally, Your Honors, I would also add that in a recent 2016 decision from the Southern District Bankruptcy Court, in fact, the Chief Judge, Henry Elowitz is the name of the decision, 550 BR 603, clarified that court's the majority position is that when a borrower surrenders their property in a Chapter 7 bankruptcy petition filing, they should be judicially stopped from thereafter contesting a mortgage foreclosure action. That we presented that in our brief as an alternative basis to affirm the trial court in the event the court is inclined to adopt one of Mr. Bonfiglio's arguments related to standing or notice or a reformation. Here, the borrowers filed a Chapter 7 petition in bankruptcy where they surrendered the property at issue. They got absolved of any debt they were obligated on the note. And so the foreclosure action only related to the in-rem property. It didn't concern the several $100,000 that they owed on that note. And so the bankruptcy court recently identified the majority position of courts in that situation is that a borrower should be judicially stopped from after giving up that prop, surrendering it and obtaining a discharge on the financial liability relating to it. They shouldn't be able to come into court, state court, and raise these kinds of defenses to subsequent foreclosure proceedings initiated by the lien holder.
Is that binding on us, that decision?
No, Your Honor, it is not binding on you. However, I just merely wanted, there have been a lot of recent decisions on it from bankruptcy courts, the parties we both cited to some in our brief. And actually one, Falia, is on appeal to the 11th Circuit, and that may provide further guidance once that decision is released. It could be released any day. That still wouldn't be binding on this court, but it is certainly persuasive when the presiding chief judge of the bankruptcy court for this area says the majority position is this, and that supports our alternative basis for affirmance that we set forth in our brief, that judicial estoppel should preclude this appeal or a reversal of the judgment of the trial court. So we would ask that this court affirm the judgment of foreclosure issued by the file court. And if the court has no more questions, I'll cede the rest of my time.
Okay, thank you so much.
Thank you.
The doctrine, the mortgage follows the note, doesn't add anything to this because the original note, we know based on the record, said pay to the order of the U.S. Bank as trustee without identifying the trust several months before they filed the lawsuit. And we know that there are approximately 137 different trusts that U.S. Bank was the trustee for based on the trial evidence. So the fact that the mortgage follow, the lien follows the debt really doesn't add anything to this. The problem is, and I think 689.07 trumps that doctrine because you have here a situation where you have U.S. Bank as trustee without identifying the trust, and I think I counted them out to over 100 different trusts that this could relate to. This is important in this case because my client could be sued twice because this is a negotiable instrument. Once by the party who claims to be the owner of the mortgage and note, and once by the party who perhaps may have lost it and said, I'm the one who's entitled to enforce this note. That's the critical distinction here. We have 689.07, which says, when you hold as trustee without identifying the trust, you sue individually. The second point I would like to bring out, Lossner, and I'm not going to presume to tell Your Honor what you wrote in Lossner, but the distinguishing factor here is that the record shows my client owned two properties in that tract, right next to each other. So there's no evidence that my client intended to give a mortgage on the other piece of property that she owned as opposed to this street address property. And that's where their clear and convincing evidence fails. The fact that I stipulated that the legal description is incorrect doesn't prove which piece of property they intended to mortgage. Was it the property that was, I think ends in a 9 street address versus 03, which is the second property that was owned, shown in the bankruptcy schedules. So again, they needed to bring in somebody to testify, we intended to give or we intended to take a mortgage on this particular piece of property. Their proof failed on that particular point.
All right, is there anything further?
That's it. Thank you.
Thank you.